Senator Mitchell, as an alumnus of this committee, I really appreciate your coming back. You'll be speaking on SB 176, SB 227, items 3 and 4.
Yes, sir. Thank you very much. And I miss you. Hello to your efficient crackerjack staff. May I begin, please, sir, with SB 227?
Very good. Item number 4.
Thank you very much. Good morning, colleagues. I'm very proud to be here today to present SB 227, which prohibits the use of a criminal grand jury when evidence indicates a peace officer's use of excessive force or a firearm may have contributed to the death of a person being detained or arrested by that peace officer. The grand jury system has recently come under fire nationally in the wake of several incidents of officer-involved deaths. To the public, the outcome of the criminal grand jury proceedings can seem unfair and inexplicable. The criminal grand jury system lacks transparency and is not adversarial in nature. No judges or defense attorneys participate. The rules of evidence don't apply. There are no cross-examination of witnesses, and there are no objections. In researching this topic, I've been struck by the lack of available information on how the criminal grand juries are used here in our state. There appears to be no data on the number of cases that are heard, the kinds of cases that are heard, or the outcomes of those proceedings. And yet the decisions rendered by these juries have critical public policy implications. Some counties have recognized this predicament and have taken action. My home county of Los Angeles, as well as Santa Clara counties, have adopted policies that preclude the criminal grand jury being used in cases, again, where an officer's actions may lead to death of a suspect. However, these policies have been instituted at the will of the county's district attorneys and are subject to change at any time. This bill does not create a different path for these cases. It merely requires that peace officers, It merely requires that peace officers' cases be sent through the preliminary hearing process when a civilian death is alleged to have occurred as a result of said officer's actions. The use of the criminal grand jury has fostered an atmosphere of suspicion that threatens to compromise the very nature of our judicial system, and as such, it's not serving its intended purpose as a useful judicial tool. The public fundamentally has a right to know that such a grave allegation is taken seriously and is investigated thoroughly. SB 227 is a step towards restoring faith in our justice system and in our communities. I'm very pleased to have with me today retired Judge Ladoris Cordell, who has written extensively on the overall concept of reforming the grand jury system. From San Jose, she'll be my expert witness, and I respectfully ask for your aye vote.
Okay, 2 minutes.
Thank you. Thank you very much for the opportunity to address you. I'm Ladoris. Put forward. Thanks. I'm Ladoris Cordell. I am currently the independent police auditor for the city of San Jose, and I'm a retired state court judge, having served for 19 years in Santa Clara County on the Superior Court. This country is experiencing a crisis of faith in the criminal justice system like never before. The trust gap between communities of color and law enforcement in many of our cities is steadily widening. If we are to restore faith and narrow the gap, the time to do so is now. And as representatives of the people of the state of California, you have the ability and the responsibility to do so. SB 227 will lift the veil of secrecy over criminal proceedings in the aftermath of officer-involved shootings and other uses of force that result in death of civilians. Instead of convening secret grand juries, this legislation will mandate the use of public preliminary hearings, which are adversarial, presided over by judges, and in which both sides are represented by counsel. SB 227 is a win-win for Californians. It has no fiscal impact on taxpayers. The transparency and accountability it will provide will significantly improve the public's trust in the criminal justice system. And it has already successfully been implemented in 2 of California's largest counties, Los Angeles and Santa Clara. The opposition to SB 227 is de minimis and it's weak, and I'm not surprised. The Grand Jurors Association opposes this bill because of a slippery slope concept, the concern that it might eventually result in abolishing the grand jury. Their slippery slope argument has no merit because the grand jury proceeding is embedded and authorized by the California Constitution. Only a 2/3 majority of the voters of this state can authorize the abolition of the grand jury. SB 227 does not violate the constitutional authorization of the grand jury. It is noteworthy that the Grand Jurors Association
One moment.
was...
Are you the only, is she your only witness?
And these others will just do their Me Too.
Okay, fine. So go ahead. We'll give you the full 4 minutes.
Thank you so much, and I'm almost done. It's noteworthy that the Grand Jurors Association was silent on the substance of SB 227. They did not take issue with any of the arguments in favor of the bill. The California District Attorneys Association, CDAA's opposition, is notable for what it does not say. In their letter dated April 14, 2015, to Senator Mitchell, they did not dispute that criminal grand jury proceedings in California are secret, one-sided, non-adversarial, and controlled by prosecutors. They did not address the fact that the public preliminary hearings serve the purpose of grand juries, and most importantly, the DAs of Los Angeles and Santa Clara counties have opted not to utilize criminal grand juries in officer-involved fatalities. The CDAA, in their letter, proposed a compromise. Their word, not mine, compromise. They proposed that grand jury transcripts be released to the public in deadly force cases where no indictment is returned. Current law allows for the release of transcripts only if there is an indictment. Their proposal makes no sense because the release of transcripts of an unindicted person, in this case, a law enforcement officer, would undermine the justification for keeping the grand jury proceeding secret. The courts have long held, and I quote, "Secrecy is justified today by the concern that persons who are investigated by the grand jury, but against whom no indictment is returned, should not have their reputation sullied." Now, what I find interesting in this discussion that the CDAA's proposal would sully the reputations of unindicted law enforcement officers.
Your time is up.
Okay.
Thank you. Go ahead. Other witnesses in support.
Frank Leidman on behalf of the Criminal Trial Lawyers Association of Northern California. We're a private defense bar with public defender members as well. We're in favor of this and are happy to say me too and yield to Judge Cordell.
Micah Doctoroff on behalf of the ACLU of California in proud support of the bill.
Ignacio Hernandez on behalf of the California Attorneys for Criminal Justice, a statewide association of criminal defense attorneys, in support of the bill.
Very good.
Philippe Ostagai on behalf of the California Public Defenders Association in strong support of this bill.
Jim Lindberg on behalf of the Friends Committee on Legislation of California in support.
Any other witnesses in support? Then I'd like the witnesses in opposition.
Mr. Chair, members, Marty Veronikar representing the California District Attorneys Association. We were opposed to this measure in the Senate, and I'm here today to reiterate our strong opposition to this measure before this committee. Senator Mitchell's bill seeks to limit the power of the grand jury to issue an indictment in cases of officer-involved shootings. Our opposition to this measure is rooted in the history of California's Constitution. The California criminal grand jury is a creature of both the California Constitution and common law. Its core function, investigating and indicting criminal cases, can only be modified by the Constitution, as was done by Prop 115. In Fitz versus Superior Court, a 1936 case, the California Supreme Court stated its position that the legislature was given no additional powers over the grand jury than those it had under the Constitution of 1849. The legislature can only make changes involving procedural matters, such as allowing an additional indictment grand jury for L.A. County, as was codified in PC 904.8. Our position is that this legislative attempt to take away crimes that the grand jury may consider for indictment is unconstitutional. It strikes at the core function of the grand jury to issue an indictment if there's probable cause to believe that a crime has been committed. The grand jury system became the subject of intense national discussion and much criticism, particularly after grand juries failed to return indictments in several high-profile cases involving police officers. No similar criticism was voiced after the May 21st grand jury indictments of 6 police officers involved in the Freddie Gray case in Baltimore. It makes no sense to create a possible unconstitutional change to the grand jury's power to indict based on the type of crime charged and the occupation of the suspect. We have other concerns which go to the misunderstanding of the process. When SB 227 was heard on the Senate floor, Senator Mitchell stated that the rules of evidence do not apply.
Excuse me, could you just sum up in a sentence or two?
Thank you. Perhaps a more moderate approach, as we indicated in our letter, would actually make the grand jury process more transparent, and that would be to modify Section 938.1 to allow for the preparation and public disclosure of those transcripts in deadly force cases. Thank you.
Thank you.
John Lovell on behalf of the California Police Chiefs Association. Stop for a moment and think. Several weeks ago, this committee put out Assembly Bill 86. The gravamen of Assembly Bill 86 was that in these types of cases, district attorneys are not to be trusted. They're to be viewed skeptically, and instead we should have a special prosecutor. The intellectual gravamen of this bill is exactly the opposite, that all power to determine whether or not to file should be vested in the district attorney, and that decision, incidentally, is made behind closed doors. We support the need for increased transparency with the grand jury system. The suggestion of the District Attorneys Association bears strong merit. We also believe that requiring open grand juries, as is done in Santa Clara County, would also enhance transparency. Those are real solutions. One final note. I think this bill is based on a faulty factual assumption insofar as California is concerned. There have been a number of instances where criminal grand juries in this state have indicted police officers for criminal conduct. So this is a system that has worked. Yes, does it need more transparency? But the way to have transparency is to do open grand juries, is to permit the release of transcripts in all cases, not to simply vest in the district attorney. No disrespect for the district attorneys, but understand that that decision to initially file is made behind closed doors, and that is intellectually contrary to the action taken by this committee when it approved AB 86.
All right. Other witnesses in opposition, name, organization, position.
Mr. Chair and members, Sean Rundle with the California Peace Officers Association, also in opposition.
Very good. So we've had excellent testimony here this morning. I would expect we have some questions or comments from the members. Seeing none.
I'll go.
Very good. Mr. Jones Sawyer.
I want to thank Senator Mitchell for bringing this to the committee. It's probably long overdue. And the real discussion in the community is about grand juries and transparency for us, not secrecy. I think secrecy is very important, but not having the grand juries becoming ultimately transparent is what has been a problem. Mm-hmm. I have friends that sit on the Los Angeles Police Commission, for example. When they make a determination, as they just recently done in a recent shooting, you kind of become perplexed by how did you come to that? Mm-hmm. And they'll say, well, we have evidence that nobody else has. Mm-hmm. So this is why we came to this conclusion. So the 5-member or 7-member police commission comes up with a determination that the rest of us keep shaking our heads at. How could you come up with that determination? And I think it's very important, like this bill is, to kind of open it up so that we have an understanding of the process and how are these determinations made. And I'm going to allow Judge Cordell to kind of finish her discussion or her answer to the PC 938.1 question, because allowing transcripts afterwards, and I had the same question. Would this be an appropriate way to move forward and give the transparency that we needed? I'm going to vote for this bill because I think it's very important. And I also think it's very important for law enforcement officers. As someone who, quite frankly, had a non-criminal grand jury investigation put on him, me, and looking at the recommendations that came out from that grand jury and wondering how 90% of it I agreed with, but the 10% I didn't agree with. But I don't know who testified. I don't know who gave them the information. Some of the information was just plain wrong. And I couldn't retort. I couldn't come back with anything. The bad part of it is that grand jury investigation, which was on the City of Los Angeles and his real estate portfolio, became God, became the Bible, became what, and anything I said sounded more like I was making excuses for why I didn't do or not do something. But I heard through the grapevine there was a grand jury investigation. I didn't even know grand juries could look at local municipalities and see whether or not they could go into make recommendations on that. There's a lot about the grand jury that we don't know about and how they work and operate. And I think this is very important. So if Judge Cordell could finish your answer to the transcripts question, I think that'd be very important, not just for me, but for the rest of the committee.
Sure, and I'll do it as briefly as I can. So we all understand, there are two types of grand juries. There's the civil grand jury and the criminal grand jury. This bill addresses the criminal grand jury. Criminal grand juries are very rarely convened in California. We don't have accurate data on how many times. Not even the Grand Juror Association keeps track of how frequently the grand juries are convened by prosecutors in criminal cases. I can tell you from my nearly 20 years on the bench that during that time, I could count on one hand, not even fill up one hand's worth of criminal grand juries that were convened during that almost 20-year period. With regard to transcripts, the law currently provides that within 10 and no more than 20 days after a criminal grand jury has returned an indictment, that the transcript is to be delivered to the Superior Court judge. The judge then releases that transcript to the public, but can also not release it for good cause. If there's a transcript of someone who is unindicted, that transcript cannot be released. Now remember, the theory behind secrecy of grand juries is to protect the reputation of the individual who is called before the grand jury, who is being investigated. Because if there's no indictment, it's secret, no one will know, that person's reputation remains unsullied. So the proposal to, well, let's release all of the transcripts, even those that are unindicted, defeats the whole purpose of secrecy, because then the reputation of that heretofore unsullied person becomes sullied because the world will know that person was under investigation. In police officer shootings, there is not that issue because the whole world knows the names of the officers. They're released. It's public. So the issue of, well, it's important to have a grand jury on these becomes irrelevant. The person's name is known. So given that the whole purpose of secrecy is defeated, it is then makes sense to use the procedure that in almost all cases, DAs in the 58 counties in California utilize, which is preliminary hearings to find probable cause, which is the same goal of criminal grand juries, a determination of probable cause.
Thank you.
Very good. Anyone else with a comment? Go ahead, Member Lackey.
Thank you, and thank you to the author and for all witnesses who have brought this issue forward. Obviously, I honor and respect and am sympathetic to the identified frustration that currently exists. There is a public trust issue that needs to be fortified, but I just have to say that I think that this is not the right solution, and the transparency is clearly something that needs to be worked on, something that has to be confronted directly and honestly. But to change the entire process to this extreme, I believe is not only unnecessary but unhelpful. And so I believe that I'm not going to be able to support it, but I do welcome further discussions on this important issue, and I hope that we come to a more agreeable solution.
Madam Vice Chair.
Thank you, Mr. Chairman. Senator Mitchell, I think most people, all people on this dais, share your concern about what's going on with the trust factor between these grand juries and law enforcement officials that are involved. We share that, but I would have to agree that it might be a better solution to narrow it rather than to get rid of it completely, as what I understand you're trying to do with cases of officer-involved shootings. So the judge mentioned that preliminary hearings and grand jury investigations are similar in that they are searching for probable cause. So I don't know why we would want to get rid of that element, that step in the process, if both do the same. We want, and oftentimes I think in the judges that I've spoken with in my district, the grand juries, they're looking for a way to take that case to trial. A prosecutor's likely not going to bring that forward unless he or she thinks that they can get a case to go to trial. So that is the goal, right? It's not to hide anything.
Just a second. I know you're saying but we don't do back and forth, so it's okay.
Thank you, Mr. Chairman.
Oh, that was me, sir.
Oh, that was you.
Mike, yes. I'm a nodder and a meaning I understand her point. I'm sorry, that was me.
Sorry. I
understand your point.
I saw it from that, I heard it from that direction. All right.
Thank you, Mr. Chairman. And I just want to say that I don't think we want to get into a situation where we are trying these cases in the court of public opinion. That's not helpful to anyone. And I think that's what ends up happening is if we're going to turn this into some sort of circus by eliminating this particular part of the process and making it open to the public, and I just don't think it's helpful. I like the grand jury process. I don't like some of the elements that you pointed out that I agree with you on, and I think if the bill were narrower, as was suggested, I could absolutely support it. If you bring it back at another time, should this bill not make it through, I'd be happy to help with that. But those are my concerns, but I do appreciate what you're trying to do.
Okay, and you can answer those in your close.
Other
questions? So, Senator Mitchell, you may close.
Thank you very much. I appreciate the rich debate that this bill has brought forward today. First of all, I feel the need to initially say that I don't believe the preliminary hearing process is equivalent to a three-ring circus by any means. And let's be clear about the difference between a preliminary hearing process and a criminal grand jury. And I will reiterate, criminal grand jury proceedings are not adversarial. No judges or defense attorneys participate. The rules of evidence don't apply. There are no cross-examination of witnesses, and there are no objections. How prosecutors explain the law to the jurors and what prosecutors say about the evidence are subject to no oversight. And the proceedings, clearly, as we've articulated, are shrouded in secrecy. We don't even know who the impaneled grand jurors are. And so the leap between a preliminary hearing process that all of these statements I just said don't apply to compared to the grand jury, they're light years apart, Assemblywoman. And I would argue, in light of our, as you suggested, the entire committee's commitment to transparency, supporting the concept of the bill is the first step we take to get there. You know, there is a movement afoot here in California. I've spoken to many members of both the bench and bar and read any number of white papers that are suggesting the need for an overall reform of the grand jury process. This bill isn't attempting to do that. This bill is taking a very narrow view looking at a particular case. I appreciate the district attorney's ongoing and their perseverance in opposing this bill, and I particularly appreciate the focus of their comments today, as opposed to my experience in Senate Public Safety, where references to grand jury experiences currently in the media and the public that have nothing to do with a law enforcement officer were raised in opposition to the bill. So I appreciate the more relevant, narrower focus of your testimony in opposition. Again, like I said, there's a movement afoot to really take a look at how relevant grand juries continue to be in our current society. Yes, they are grounded in our state's constitution and are grounded in ancient British history, where they have now been overturned and are no longer used. And so if we're going to continue to be relevant, continue to look at a judicial system that is fair and equitable, applied to all citizens across the board in a fair, equitable way, I would ask that you consider supporting SB 227 as California looks at a way to make sure that the residents of our state continue to have a high level of confidence in the judicial system that we're all governed by. I ask for your aye vote.
Very good. So this has an aye recommendation. I think and I support the arguments that we've heard in support. I will just add that making the grand jury testimony public, as happened in the case of Ferguson, as happened in Staten Island, in no way satisfied us. In fact, we were concerned that I'm talking about myself and many others, who looked at this and said, hey, this guy wants an acquittal or wants not to bring charges. He's using this grand jury as a shield to take criticism instead of him taking the criticism. So in my mind, what we're doing here is we're saying the DA is in charge. The DA is going to make a finding of indictment or non-indictment, and they can do that through the grand jury or they can do it in public. If they do it in the grand jury, they don't have to use the rule of evidence. There's no judge. If they do it in public, we do have rules of evidence. We do have a judge. Let's have it done that way. It is extreme. This country lost its faith in the system over the last few months. This is a simple way to make things transparent, to make the system available to all. It's already being done in LA and Santa Clara County. I think it's already, frankly, although there may not be a policy, being done in my home county. DAs, by and large, are willing to take this responsibility, and we want to make sure that they have that responsibility. So, again, with an aye vote, the motion is... move the bill. Second. Okay. Moved by Member Lowe. Seconded by Member Jones Sawyer. The motion is due pass. Madam Secretary, please call the roll.
Quirk?
Aye.
Quirk, aye. Melendez? Melendez, no. Jones Sawyer? Jones Sawyer, aye. Lackey? No. Lackey, no. Lopez? Lopez, aye. Lowe? Lowe, aye. Santiago? Santiago, aye.
So the bill is out. I want to thank everyone who participated. We had fine testimony, and thank the members very much for being here and giving us their making a a decision based upon their deepest held beliefs, no matter which side you were on. So thank you very much.
I agree.
I'm going to give this to Madam Vice Chair, and I'm going to go present a bill.
Thank you, Mr. Chair. I appreciate it.